What do you call an attorney with an IQ of 100? Your Honor. What do you call an attorney with an IQ of 50? Senator. One of the most difficult steps in probating an estate is providing the inventory, appraisement, and list of claims to the court. First, you don't need to provide an inventory, appraisement, and list of claims if the following applies. On September 1st, 2011, the Texas State Legislature amended the probate code, allowing an independent administrator to file an affidavit instead of an inventory, appraisement, and list of claims. This did not alleviate the duty of the executor to provide this information to the beneficiaries. It only allows for an independent administrator to not disclose assets of the estate to the public. An affidavit in lieu is authorized if the following apply. First, authorized in the will. Second, no unpaid debts of the estate. Now, this doesn't include if you have secured debt, taxes, or administrative expenses. All the beneficiaries in the estate have received an inventory and appraisement unless they're going to receive less than $2,000 or they have received their whole specific gift that they were supposed to receive that was laid out in the will. Or last but not least, they all sign a waiver receiving an inventory and appraisement. You have filed that affidavit within 90 days of receiving letters. The inventory must be filed. It must be in writing and it must be verified. It must include all the real property located in the state of Texas. It also must include all the personal property, no matter where it is located in the whole world. Last but not least, it must specify whether it is community property or separate property. The personal representative should do the following with an appraisement. Set out in the inventory the fair market value of all the property at the time of the decedent's death. Or if the court hires an appraiser or appraisers, those appraisers' value that they set out and included in the inventory that you file with the court. A list of claims. A list of claims is not a list of debts. A list of claims are the claims that are due and owing to the estate. In other words, this is what is owed into the estate. We do not list any debts. The list of claims must state the name, the address, and any other important information of the person or entity that might owe money to the estate. In addition, the list of claims should list out everything else that is known about the debt that's owed to the estate, whether it's a note, a bond, or any other important information. Last, the list of claims should list out the amount and the interest rate that is owed to the estate and the period of time over which it's supposed to be collected. If you are an executor or an administrator of an estate, you're going to know that this is going to take some time to put together. I have created a Google Sheet where I provide a place for you to enter all this information in to make it nice and easy for both of us as we're going to put this together and finish this for the estate.